Today, we'll be talking about the powers of the Attorney General. Now, when we talk about the Attorney General, remember that we have an Attorney General of the Federation, and then we have Attorneys Generals in respective states. So on this section 174 of the Constitution, you have the Attorney General of the Federation, while on the 211, you have for the respective states. Now, there are three powers the Attorney General exercises constitutionally. One is the power to institute and undertake criminal proceedings in any court. Two is the power to take over and continue criminal proceedings. And three is the power to take over and discontinue criminal proceedings in any court in the land. And of course, these powers of the Attorney General may be exercised in any court except in the court martial, right? That's the only court in which the Attorney General does not have that power to exercise. Now, of course, the power to institute and undertake means the Attorney General could go to any court and institute a proceeding. The power to take over and continue is the power whereby another person could have brought the proceedings, but the Attorney General comes, takes it from the person and carries it on to the end. And the power to take over and discontinue is the power whereby the Attorney General takes over the proceeding from another person and ends it, he stops it, prosecution stops. And that is a very important power, which we refer to as the power of nolle prosequi. All right, the power of nolle prosequi is the power the AG has to take over and discontinue criminal proceedings. Now, how is this power of nolle prosequi exercised? It's exercised at the absolute discretion of the AG. Now, what that means is that the AG does not need anyone's consent in order to exercise it, and the AG does not need to give the court any reasons as to why he has chosen to exercise it. And of course, the case of State and Ilori is authority for that point. Now, how is this power of nolle prosequi exercised? Now, it must be exercised by the AG in person, orally in the court. Otherwise, he could have a written instrument which he has signed and given to an officer in his department to present to the court. All right, very important, an instrument signed by the AG, which would be presented by an officer in his department to the court. Now, it's not possible that an officer from the department of the AG could appear in court to exercise that power of nolle prosequi. It must be by the AG in person, otherwise he'd be sending an officer in his department to do it on his behalf by handing that written instrument to the court. Now, you find that there is a similar power to nolle prosequi, which prosecutors may exercise, and that's the power of withdrawal, all right, whereby the prosecutor informs the court that they've chosen to withdraw proceedings. Now, you see that it's quite different from nolle prosequi in many different ways, particularly because with withdrawal, you need the court's consent and you need to give reasons to the court why you've chosen to exercise that power. But very importantly, another big difference is the effect of nolle prosequi and withdrawal. Now, when nolle prosequi is exercised by the AG, the effect of exercising it is a discharge, all right? A discharge. It leads to a discharge, which means that the accused person may subsequently be tried for the same offense in the future. Whereas when a withdrawal is exercised by a prosecutor, if the withdrawal is exercised before the accused person opens his defense, then it leads to a mere discharge, whereas if it's exercised after he has opened his defense, then the result of that is an acquittal. So that's all for today. I hope you've learned something new.